12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes, 2025.
So we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. And they move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
Yeah. I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching
Campus Drive.
And again, broken into quadrants. Where is he currently?
In the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
And is this the same wooded area where they found the rifle later?
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located? If you broke it into quadrants.
It's on the left side, on the upper side, the upper quadrant.
Now, what do we see?
And that vehicle's now pulling away and heading east on 800 South.
And why do you believe that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
Okay. And do you know who that officer is?
Officer Goforth.
Okay. And do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay. And what time was that interaction? I'm sorry. Did I ask you that?
It was approximately 12:30 a.m.
Okay. On the 11th?
On September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during, I guess during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He did, yes.
Okay. And who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Let's return again to what's been marked Stakes Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as Stakes Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, what would be specific about the enhancements? And let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it. Red highlights.
Yes.
Do you know what he's or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that? Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage and their faces were blurred.
Is anything other than faces being blurred?
Not that I recall, no.
Okay. And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed.
Yes.
From 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop.
Mm-hmm.
I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video?
No.
The accuracy of the video in your mind?
No.
Okay.
Can offer it?
Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the Losi rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted to evidence. We believe there's enough foundation that at this point, we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two.
Yes, we know you did.
Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to Utah Rule of Evidence 403 to the last phrase. Presenting cumulative evidence. So the court may, let me just read the whole rule
Cumulative.
for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the two videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right. Well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is
What?
I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining the probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge? Or maybe
Sure.
one run request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because
I see.
we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did. But we had to memorialize it and save it. And then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion.
No,
we're
that's
zooming in.
the
How long
worst
is that,
part. She doesn't
Mr.
want that.
Sturgill?
I think it's a couple of minutes.
Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at. So all parties can see clearly that the court is reviewing it in court, but I do not find that it is necessary for its publication because this is the exact same video. I recognize it's zooming, but in balancing the constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's
He's
free to view it
struggling.
with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break where we
Sure.
can start. And what I'm going to ask is just we simply play the. You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I
Okay.
will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
Oh, Judge was
If I
struggling
just have one moment. Hold on, Billy.
to find a reason and articulate it.
Power button is.
I don't think this is the right call, but I think his
There we go.
I appreciate his motivations are to protect the
All right,
defense.
counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right. Thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view.
And he doesn't want to be the one saying it's obviously super prejudicial to the defense to show it publicly. Oh.
And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping as we go, or when we finish is fine. I just want the record to be complete.
The difficulty in doing that is because we've zoomed in, it's removed the timestamp on it.
We've seen the zoomed
So
in
you
of
can
him
just give
coming
me
off the roof.
The count
The
on the
count
video.
on the bottom, there's a timer at the bottom of the total length of the video. So that's fine. I'm just trying to create a record of what exactly I'm looking at.
The FBI released the zoom in of him coming off the roof and taking off through the parking lot and all that. But the beginning of the video we have not seen. The person coming over the railing, going into the prone position, etc.
We pause on the court system.
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
Easier for everybody if you just showed it to us all, Judge. That's been working great.
On the video was just before 6-minute mark, Judge.
All right.
So the record's clear. This is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Holt, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
So I don't completely disagree with this. You know, I think for the most part, he has been good about saying he believes it to be Mr. Robinson and not it definitively is Mr. Robinson. But that said, in this particular context, I kind of think it's fine for him to do that because this is about probable cause and it's about what the police believed that led them to conduct the investigation, focus on a suspect, develop the evidence, and ultimately, you know, lead to this prosecution. So it's the reasonableness of the accusation that has stemmed from all of this that's at issue in this hearing. So I don't see it as being like the worst thing. It's way worse in front of a jury to be doing the like implicit opinions on guilt and stuff like that. But it would be better, I think, if they made a point of being strict about emphasizing that it's just what they believe and not something that's been definitively established. At least not at, you know, not at this point, not based on this evidence. Not only is hearsay commonly allowed in many states and contexts, this came up in the briefing on the motion to exclude all of this stuff. There's not a case where they've said it's not okay. No court has ever said it's not okay to use hearsay at a preliminary hearing. It's unconstitutional. Multiple courts have said it's fine.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
Sorry. Judge, at 8:23, we stopped the video.
Oh, 8:23. Okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Holt, you were able to watch that zoomed in version. Is that
Yes, sir.
right? Okay. And was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Mm-hmm. Okay. And you can see clear the clothing that he's wearing.
Back to leading.
Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection and that you may move forward.
Is it easier to see? Oh, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Wolf.
Ms. Nestor.
One moment, Your Honor,
Of
if I may have
course.
the court's indulgence.
Video from the Washington County Sheriff's Office is on the evidence list. We have not seen it yet, but it is anticipated to be forthcoming.
Thank you. Do you want to take your
And I was just going to suggest that. It seems like right now is a good time to take our morning break. Is 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Holt. Court is now in recess.
My banner's up. Oh, doing our recess. It's probably more of a 15-minute, but we'll call it 10 just so we're ready. Well, strategic misfire on the part of the state there. Shouldn't have played the you shouldn't have played the unedited one. What he should have done is he should have just got them both into evidence. Now that I think about it though, I don't know that he could. I don't know that he could without being able to see, the original. But his whole foundation for the alterations, the zooming and everything was that it's the same thing. This guy looked at it. He compared them. He sees what they did to it. Doesn't think it affected the accuracy in any way. So, hindsight. I suppose if he had done it differently, and the judge still just really doesn't want us to see this part because, whatever reason, the prejudice to the defense, okay? The prejudice to the defense, the right to the fair trial. This is the justification. We kind of know what that subtext means. It's not good for him. But just, strategically might have been better to go ahead and just get it all admitted into evidence, and then you get to choose which one you want to publish. Maybe. I don't know. Boy, watching Judge Graff struggle there to articulate a reason for us not to see it. And, we just had this back and forth with the media council. He knows it's a high standard. It's a compelling interest that has to be shown. Narrowly tailored to justify the restriction. Having a hard time articulating what's exactly compelling about this, particularly in the context of all the rulings that he's already made, that, the publicity isn't ideal, but that's why you have all these additional protections in jury selection, and you can call more people and have questionnaires and do individual questioning and all of those types of things. So a little bit of a sudden shift. That is not real clear why, but it's fine. I still love Judge Graff. I'm not always going to agree with him, but I have just really come to appreciate more and more the philosophy, the attitude I'm getting from him. He really does seem to be extremely concerned about the fairness of the process. I can't have a problem with that as a motivation. Might not agree with him about how it plays out in any particular ruling or challenge, but the motivation, unimpeachable. Can't argue with it. He wants to protect the defendant's right to a fair trial. Oh, that video in the garage was extremely clear. When I think it was, I can't remember now if it was Ballard or McBride who gave us that recap in the earlier hearing about here's what the evidence is going to be that we presented at the preliminary hearing. I think it must have been Mr. McBride. And he says, the stuff in the morning, it's really clear. You can see everything very clearly. The ones later in the day, conceitedly, maybe not so much, but the ones earlier. Yeah, he wasn't lying about the quality of that video. That is quite clear. So I'm sure that has already been screen captured and blown up and everything like that out online. And we can see exactly how clear it is. The wheels, I'm still really not sure about these distinctive wheels. Really not. I don't know what model year Challenger this is. Somebody I'm sure knows that, but I'm not sure what model year it is. I would like to know what's the stock wheel, and then what are the trim options, because it's a common upgrade for a sports car, especially. Fancy trim, fancy upgraded wheels. I'm curious. How distinctive is distinctive? Like, okay, maybe it's not the stock wheel. It's like a big variety of options between the stock wheel and, the 1 in a million custom carbon fiber fancy racing wheel. It looked like, yeah, maybe it's a mod. Maybe it's like an aluminum upgrade or something, but I don't know. Just personally a little bit curious about that. Well, we got all kinds of law here to look at in our recap tonight. Just in case a few hours of nerding out last night wasn't enough, we're gonna get to do it again. We get these additional citations about the First Amendment stuff. Yeah, I do love that. I do appreciate that. Well, I did kind of expect more from Agent Hull, but looks like this is it for his part of the investigation. So after we get through the cross, I think we're probably going to turn to Davis, Agent Davis, the other lead investigator, and then pick up with his part, his stuff that he compiled or took charge of or whatever. I kind of wonder what the division of responsibility between them was. There is an issue. There's a lead investigator, a little bit like, having the captain of the ship. You need to be the one in charge of everything. And when you have two captains, just not always a good recipe for a successful mission. So I wonder how they divided their responsibilities between them. If it was just a total sharing of all authority and calls and everything like that, or if there was some kind of distinction. You're going to handle this part, you're going to handle this other part. Hull didn't say. May not matter at all. It's just something I personally am a little bit curious about, but don't know that it's real critical for this hearing that we're in. Mr. Burt really over-egged the pudding with his argument about the publicity and particularly the study, the public opinion poll. I continue to not be able to get over that public opinion poll that they did and how incredibly defense favorable it is. Definitely relative to Koberger. Oh my Lord, Koberger is literally like 98%, 95% of people. And just large numbers of not just they've already decided he's guilty, but they are not changing their mind. They will actually say out loud and admit, nothing I see could change my opinion about it. And then we get this Tyler Robinson poll, and it was like 46%. It's like not, and a lot of people commenting about their doubt, their skepticism. He was a patsy, all that kind of thing. Like, it's just the disconnect between the evidence they have of the public opinion in this case versus Koberger, it's quite wild to me. But characterizing all of the coverage as pro prosecution in every story, no man, come on, don't piss on my leg and tell me it's raining. We just had a whole hearing over that stupid Daily Mail article about the case is falling apart because of the tool mark ballistics, the tool mark analysis. No. No, even if you have like a technical kind of distinction in your mind between mainstream or conventional media sources and then the online commentary and the new media and so forth, even if you make that distinction, there's plenty of mainstream commentary like the Daily Mail that has not been pro-prosecution. But I mean, that is his job. That is his job. It's just I'm gonna notice. I'm gonna notice when you're like, no, and it's just like, no, that's too far. That's too far. Like, yeah, you could say you have a public opinion poll that shows that the opinion is being affected and that there's people that already think he's guilty and stuff like that. None of that is untrue. Like, why do you have to try to turn it up to 11 and just take it too far? It's not every single story. Oh, well. How are you guys at? I see we got some new members coming through. KPH 500, welcome. Welcome, Allie B from Tennessee. Welcome, Allie B from Tennessee. Lucy Fair, haven't seen you in a minute. Welcome back. Welcome back. Willow's Angel, just a good morning greeting to you from California. What a nice greeting. Thank you so much. Good morning to you too. Just had my wonderful time down there in California. I'm in Sequoia. Fantastic. Really enjoyed that. Hope to make it back soon. Well, I know I'm going to make it back soon because I know I have to go back down to pick up Alice Evans's trial exhibits, which the judge wants to hand to me in person in paper form. So I get to go back down to LA for that. So anyway, I'll, of course, try to find a way to make it fun. The real CH3. After Richens, I don't know if I can do another long trial with Ms. Nestor. I physically cringed when I heard her name yesterday. This seems to be a real common reaction. I get it. I didn't watch Corey Richens, really didn't pay any attention to it at all. I know it's one of those things like I probably should. We're just not at a time of the year and everything. We're like, I really want to sit down and watch a whole long ass trial. I mean, I will if there's something that like we can't miss, but so far it doesn't seem to me like there really is. So haven't really wanted to do that, but we might have time. We might have time to go back and do maybe at least a partial rewatch of some of Kathy Nestor's finest moments in the Corey Richens trial. If you have any recommendations, I've already got the tip for the motion for the new trial. Check out the motion for the new trial. I will do that. But if you got any points in the trial or anything like that, you're like, Andrea, you got to check this out. Hey, feel free to let me know, and maybe I'll make a little list of things to watch and react to or something. I mean, I get it. Even when you're really, really good at it, defense work can also often come across as kind of obnoxious, kind of difficult, kind of disagreeable, kind of causing problems. You know, it's not a popular job. It's not a popular job. It's much easier, of course, when you have a case where there is nominal evidence, very suspect evidence, suspect witnesses, things like that. Basically reasons to think we are pursuing a factual innocence defense. But when there's a lot of evidence and it starts to pile up, and you start to be like, why are we even here having this trial? then the defense's involvement, even when they're really good at it, it can just come across, I think, sometimes as a little bit obnoxious. But it doesn't help. Doesn't help if you have a strategy and a style of being difficult, making it as hard as possible to get through the process. I do get that. So we'll see. Seems more mellow today. The whole call out about we don't need to hear the same objection over and over again seems to have landed. We're still going to get other objections, obviously, but can't hold that against her. I love pussycats. I know he is a newer judge, but watching the Senate Judiciary Committee for nominations is night and day. I hope one day he goes up in the judiciary. Who's the senator who always has, I can't remember now who it is. He's always got like some kind of gotcha jurisprudential question for the nominees that they're considering. I can't remember now who it is. But yeah, I'm very impressed with Judge Graff. I mean, we've seen a lot of judges, a lot of different judges, in these high profile hearings. I've of course seen a lot of judges in my private career. I don't know what it is. I mean, I do know what it is. I know what it is about the position. It's the fact that it's a position of power and prestige that attracts a lot of the wrong kind of personality. But just you just get so accustomed, it's so like normalized to see judges on the bench who are clearly biased for or against one side, impatient, short-tempered, lose their shit over things that don't warrant it. We've all seen it. Anybody who's watching like any of the cases in Massachusetts is seeing it. Seems to be like almost a prerequisite to get the job in the first place, is to have this control freak kind of personality. So it is just such a breath of fresh air to me to see a judge who's not like that in a very important, a very high profile case like this. I am impressed with his judicial qualities so far. Allie B from Tennessee, can someone put a good word in for me to the judge? I haven't seen a wedding ring on him. Oh man, it begins. It begins. Judge Silver Fox is going to be a celebrity whether he likes it or not. I haven't looked. I haven't seen a ring. I haven't looked. Oh, I guess we're all going to be paying very close attention now. See what we can ascertain about Judge Graff. Amy Abadi, thank you, mods, and Andrea and Jeff Burkhart and Burkhart Cats. Thank you, Amy, for being here with us this morning. Oh, I highlighted this, Cedric BLHK, because you've inspired me. I'm going to go ahead and see what I can find in terms of some case law, and we will talk about this on the recap tonight. I will take a look at that for you. My knee-jerk reaction is thin. It's thin. It's not a gimme. Not a gimme with a jury, for sure. I mean, a single shot that landed on target, endangering a whole bunch of people. It's not typically what you're probably thinking of with this type of situation. You're thinking like the drive-by that sprays up the whole neighborhood. You're thinking about the planting an explosive, something like that. Something that just the risk to multiple people is evident. The irony in this situation, though, is it's precisely the lack of exit wound that the state is going to point to. The improbability, the fact that this is not the probable outcome from a shot, from a rifle. It's not the probable outcome that it's going to be retained. It's not 51% likely that the bullet's going to be retained. It's less than that. It's a low probability event. But it's only because that low probability event occurred that the bullet did not, in fact, pass through. where it could have endangered other people that were nearby. I think that's going to kind of be their hardest factual thing to establish. It's what they're going to need a lot of this camera footage and stuff like that for, is to be able to break down who was in the vicinity. You know, how could this have gone awry? Like, what are the kind of different ways? Just because, yeah, it's thin. It's thin. It's like, well, he could have hit somebody else if he didn't have his aim quite right. Yeah, but he didn't. He could have also hit a lot of people if he fired the gun like 20 times, but he didn't.
And we're
Back up
picking
in
up with
court.
cross-examination of Agent Hull. Ms. Nestor, your witness.
May it please the court. Thank you. Good afternoon, Agent Hall.
Good
You
morning.
and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So
So,
when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year.
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay.
oh,
So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the.
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that or were you not
It's
involved?
not, no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge.
For the first 2 hours, I wasn't. I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Low-C building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
that's correct.
cartridge?
when a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
I
Do you know
doubt
where
it.
that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were all ultimately cleared by you or somebody connected with you.
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun,
Any other guns that were found on the scene?
not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster.
He did recover
Refresh
it.
your memory.
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor.
So they did get the holster.
And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Poll 13 and just show it only to the witness for right now?
This is typical
All
cop.
right, can we go to page 2 of that report? Do you
They
recognize this
become-
report? Have you reviewed it as part of your
Amnesic.
investigation
As soon as
duties?
it's time for
I do
cross.
recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day.
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believe there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
Exactly.
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline. Is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
It's like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay. And so it was actually Sergeant Bricker that prepared the timeline. Is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Did he?
Yes, I believe
I
he
heard
turned
he
himself
had
in
it.
on September 11th.
So prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
Okay, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof.
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that. Is that right?
Excuse me. Determine who he was or
No.
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct,
from the parking garage.
correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone
Yes.
was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
So I'm not sure I understand the question.
Did you at some point in your investigation collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video. Is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay.
Because the gun was
Also, when
covered.
you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay.
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay. Thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct.
And it showed like a dead on view of Mr. Kirk and his parts of his security team.
Don't
Is that
say a
right?
dead on view.
And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr.
Are
Kirk.
you referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49?
Words,
I want
Kathy.
to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Yeah, sure.
Are they approaching the bench, having a little sidebar? Guess they
And
want to
Ms.
make sure we
Nestor,
don't
as
see it.
you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Stop.
Approximately.
Okay. So what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
Well, there's a videographer on the right side of the tent. And then I can only see as far as the video allows me to. So I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent. No.
Thank you.
He knows where she's going.
All right. I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right.
The judge
Is
does.
it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us. Yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you.
Witness is squirrely, doesn't want to be pinned down.
All right.
He senses danger. So he's
Were
like
you
always.
involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value. And then it was secured. And then I was notified that as a result of that search, a gun had been located. Yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I was
analyzed?
not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report. No, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay. So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence. Yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble, yes.
And do you recall what they told you about what they remember
We
seeing
knew about the
in and
fragments.
around that car that night?
It's in the ATF report.
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole? Sorry, just a moment. Let's see.
Bullet fragments from Charlie Kirk's body
Hole
during the
48.
autopsy, per the ATF report.
This is Miss Noble's interview. Do you have it?
4 bullet fragments and 1 bullet jacket fragment, per the ATF report.
All right. Do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Okay. I want to go back, if I can, to the scene itself, the preservation of the actual scene where where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I
Nobody
don't
said a
know
casing,
specifically that area, but I
Said a
do know
bullet
that canines
jacket.
were present or a canine was present on the day.
not a
But you don't
casing.
know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct.
You received tips of death threats that Mr. Kirk had received before, the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was
you.
a confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay. And a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
Okay. And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
That's their mitigation case. And frankly, it's a good
And
one.
as far as you know, Mr.
Voluntary
Robinson
surrender?
did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in.
Okay.
In terms of what you've described, I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
That's a good mitigation case. It really is. It's always the cover up, never the crime, right? So avoid the
Thank you,
cover up
Agent
and you
Hall.
avoid a
It's
lot of
under the witness,
problems.
Your Honor.
Thank you. Redirect by the state.
Just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. Is your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of, if on the 10th, there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus.
Mm-hmm.
So there was a large rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which is we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars. So I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
And that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail?
It appears to be black, and it appears to be longer.
Okay. Anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video. Is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner
Sure.
in that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay. And
You're referring to the back of the pop-up tent?
correct. Yes.
Okay. Yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you can't see through it. It's white,
Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Miss Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Miss Nestor had you look at. Is that right?
Correct.
And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot. What's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been between today and yesterday that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of
They
the?
appeared to be the same.
You're aware that a rifle was eventually discovered,
Yes.
and was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th.
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event.
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement. So
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes,
Okay. So identities of possible shooters.
correct.
Did law enforcement follow up on those tips as well?
They did.
Miss Nestor, finally, Miss Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was a Washington County Sheriff's Office.
Yes.
And you understood that he turned to, well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the low-C building, is there, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position
Correct.
and then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May
Bless
Agent
you,
Hull
Ms.
be
Nestor.
excused.
All you haters.
All right, Agent Hull, thank you.
Thank you.
All you haters, she sits down and shuts up.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
5-minute break. Oh boy. That's going to be quick. You're going to make me change my banner for that. It's fine. That's fine. Sure, everybody knows we're on a 5-minute break. Well, how many times did the defense say he voluntarily surrendered himself? How many times did they say that? Yes, I know it's been part of the court record and there's been no contradiction of that by any of the people involved, but I understand it remains a source of chatter. This is why you wait for the defense to tell you what the defense is. I mean, this is why. They're not taking issue with him voluntarily surrendering himself, going to police, turning himself in. They're not taking issue with that. So they are building their case in other ways. We can already see little hints of it. Building up little possibilities, things to highlight. Another bullet, another gun. What does this mean? Maybe it was somebody else. Maybe Tyler turned himself in because he really believed he was the shooter, but he didn't actually. Somebody else did it. Managed to like simultaneously pull it off. I mean, I don't know. We'll see, but he voluntarily turned himself in. They're not contesting that. And it wouldn't be smart for them to contest it because it is such good mitigation evidence. I saved this, wanted to pull it up. Joy Morris, could you explain what you mean about Tyler turning him in as good mediation? It's mitigation. And so this is going to the penalty phase of a capital trial. If Tyler is convicted, then the question becomes, what's the sentence? Does he get death or does he get life? And so the first step is establishing if there are aggravating circumstances that warrant it and what there are. So in this case, the state has alleged as the aggravator, he endangered other people. So that's what they have to prove. Even if there are aggravating circumstances, however, the jury has to weigh that against mitigating circumstances. And so mitigating circumstances typically have to do with the character of the defendant. Is this in character, out of character? How did he behave? What's his background? Is he, the kind of kid who was sort of like born with no chance and was always going to go down this road? Or is he somebody who, deliberately and maliciously took a turn for the dark side. Voluntarily surrendering himself is evidence of taking accountability and not denying. Now, I realize that's at least theoretically somewhat inconsistent with going through this legal process, making the state prove it. I don't see it that way. I think that most lawyers probably wouldn't see it that way because it is your right. It is your right to make the state prove it. It always is. And the fact that you exercise your rights is not something that can be held against you. They can't treat that as a bad thing that you did. But he had no obligation to turn himself in. And the fact that he did so is highly incriminating. They didn't even have his name. And then here he is showing up saying, I did it. Arrest me. So yeah, that's really good mitigation because that's not going to happen most of the time. Most capital cases, by the time you get to the point of somebody's committed a capital crime, it's usually not their first crime. Okay, it's already a little bit unusual here. And usually like not rushing to be arrested. Deny, fight, contest every step of the way, lie, try to get witnesses to lie for you, all of the classic, cover up types of things that people do to try to avoid responsibility. That's what's normal. So this is unusual, and it makes him different than most of the other people that this court and these participants in this process are going to be used to dealing with. So I think it's extremely powerful, and that's why they don't want to deny that or fight that. They're going to lean into it, embrace it, because even if they lose everything else, if they get that issue to resonate, that could be the quote unquote winning issue for them. That could be the difference between life and death. So that's what I mean by that. Ginger Puff 764, just as Andrea said, things will become clearer, and they are. The stairwell video is major. Seeing the actual video in motion, that was one of the very initial questions I had about the case. I didn't read this probable cause affidavit and be like, wow, they got this guy totally locked up. No, I mean, there's more evidence here than there was in Koberger, for example, in that PC. But it's not like I have no questions about any of it. And this was one of them because they gave us those still photos from the stairwell, and you don't see the gate in that. And there are, individual stills that show both of his legs at least partially bent. So I'm like, this doesn't seem consistent. Seeing him limp his way up those stairs, yeah, now it's a lot more clear why they were like, oh, this maybe looks a little bit sus. All those other people on the stairway, I wonder if they were able to identify any of them. Really do. Wonder if they were able to identify any of those people. Oh, the million dollar question, because did they have a geofence warrant? It would be impossible for me to conceive that they didn't immediately get a geofence warrant in this case. This has been, ongoing litigation in a variety of federal circuits. So far, only the Fifth Circuit has said geofence warrants, no go. It's a general search, not constitutional. Can't do it. You're seizing too much information from individual people that you don't suspect of a crime. They've done nothing more but be present in a place. But it has been a widespread, very powerful, not just investigative tool, but just, security period, if you can get access to that type of information. So they have a geofence warrant, might be able to track some of these other people that were on camera. Hard for me to imagine they wouldn't have done that, but I don't know. I'm always ready to be underwhelmed by what law enforcement could do in an investigation versus what they actually do. So of course, all that remains to be seen. I just bring it up as a tool that is available to them that they could use. If you were a juror, what would you lean so far? I can't really entertain this position because we're not in that context yet. The trial is going to be very different in terms of the volume of information that's presented, the detail and everything like that. This is still rough. What I am willing and have been willing to say about this case is that from my perspective as a defense attorney, having been assigned cases, and the first thing you get is the arrest report, the probable cause affidavit. Here's the evidence that we have against this guy. This is what we expect to present. And the first thing you do is you sit down with your client, you talk about that. Here's what they have. Here's what they have. And sometimes you read through that probable cause affidavit and it's like, wow, this seems like a big hole to me, you know, or this seems like a real stretch as far as like the specific charge, or their proof on this particular element doesn't look very good. Or, oh, their complaining witness is somebody that I recognize, you know, from being on the court docket a million times. I bet there might be some credibility issues here. You're looking specifically for how strong is their case. You get a real read from that through your initial just reading the probable cause affidavit and discussing it with your client. And that's what guides your investigation. And so from that, you get an idea from reading a PC, how easy or how hard is this going to be to defend? It's very easy for me, having handled many, many hundreds, thousands, not maybe multiple thousands, but well over 1,000 criminal cases, reading the probable cause affidavits. This is going to be a hard case to defend. It's going to be a hard case to defend because of the multiple layers of corroboration. If it's just one thing, if all they had was a surveillance video, it's easy. But we already know they got cell phone data. They got him telling people he did it. They got DNA. They say they got DNA. So you can't just blow a hole in one thing and establish reasonable doubt. Okay, I can blow a hole in the surveillance video. So what? His DNA is still there and he still confessed. You have to blow holes in all of it. That's hard. That's a hard case to defend. So it doesn't mean they can't do it. They have the thing none of us have, which is access to Tyler to talk to him about it. If we investigate, what are we going to find? And so that's all like the big secret. I guess they're not actually starting, but they have me nervous now. That's the big secret that none of us has access to at this point. And frankly, probably never will have access to, because that's at the core of the attorney-client privilege. We're just going to see how it plays out as the case progresses. So far, we're not hearing things like, you know, major inconsistency because Tyler was on video over here, or his cell phone data puts him somewhere else. They don't have anything like that. If they did, we would be hearing about it. That would fundamentally undermine their case for probable cause if they can prove this car isn't his, the person on the camera isn't his. There's no doubt that they would be bringing that up, and they're not. So that's what I'm willing to say. This is a hard case to defend. And that's why I tend to think it's highly likely the defense is focused on mitigation. This is a mitigation case. Many death penalty cases are. It's not about did he do it or did he not. It's about should he be killed for it? Should our government take his life for it? That's what the case is about. And it's such an important question. It's a huge, important moral question, legal, philosophical, cultural. Who are we as a people? How many times have we gotten it wrong? Such an important question, and not getting the attention it deserves, at least not yet. Base Player 2011, I guess I'm going to mute this again. Base Player 11, 2011 IFY. It can never be just a single man with a rifle. I'm getting really sick of that. I mean, it can. It is sometimes. The rifle in and of itself is like the unusual fact. You know, obviously most shootings are done with a handgun. But yeah, most murders are probably not big conspiracies, plans. They're a single person, you know, with a grievance or with an impulse, you know, bad impulse. They got real mad, lost their temper, stuff like that. Not nearly that many that are like planned and conspired. Although I will say, you know, you could put like drive-by shootings and stuff like that. A lot of gang violence would probably fit that. But outside of that context, no, you're mostly talking about domestic situations, by far the most common. So, I mean, it is what it is, you know, different cases are different. We have what we have here. Jessica Rachel, check out the prelim. They had a defense the case. We are watching the prelim right now, so I am not exactly sure what this is referring to. But thank you for your comment and your support. I'm just a stay-at-home juror. Welcome to the channel. I love that name. What a great username. A stay-at-home juror. You get to do the fun job that I wish I would get to do someday and probably will never be able to. Jessica Bell writes, first, Mrazek, now him. I need to move to Utah. Mrazek, I know, is the judge from the Corey Richins case, but as I said, didn't watch any of it, so I don't know. I am very impressed with what frankly, reading as a very Mormon courtroom. I am reading this as a very Mormon courtroom. I'm reasonably confident that most, if not all, probably most, probably not all. I don't think Kathy is going to be LDS. She's from the South. She's a transplant. The Californians, I don't think are probably LDS. But the prosecution, definitely the elected. I mean, to even get elected in Provo, he's more than likely LDS. The judge, more than likely LDS. We know there have been lots of like little comments throughout the course of the case about like in the motion to disqualify and things like that about, oh, now I'm spacing on what they call like the local Mormon community of your particular church. There's like a name for it anyway. Yeah, doesn't really matter. But that's really my read on this courtroom, is that culture is influencing a lot of what we see, and is very polite, very respectful, very agreeable and cooperative, like trying to help each other. That is something I very much appreciate about the LDS, is how much they support each other. They really, really do. They will show up to check on people that haven't gone to church in 20 years. You know, see if they need anything. You doing okay? You healthy? You need your lawn mowed? If you do, they'll do it. They'll have like church elders show up on the doorstep when you know, your dryer just went out, and they'll come in and fix it for you. Like LDS are really great when it comes to supporting their community. So I feel like that attitude is reflected here. And it's so different from what we're used to seeing with trials, because trials are adversarial. And so we're so used to seeing this just extremely combative, often like deteriorating into just attacking and insulting and all that type of thing. This is just such a fresh breath of fresh air for me. If that's common with the judges in this area, and I'm like, yeah, maybe I need to move to Utah too. Go be a lawyer there. Kyle Cowden, likely a 5.56 maybe a 7.62 by 39 common LEOUs for rifles. Yeah, I wouldn't know. I don't know that much about the rifles. I mean, SWAT is really, as far as my experience, it's usually SWAT that has the rifles, at least in my area, at least, you know, back when I was doing a lot of active trial work, like case trial work. But don't really know much about yeah, how it was chambered and stuff like that. Usually SWAT has the rifle but doesn't need to use it, so it just doesn't often come up in the course of criminal cases. So I got to defer to the LEO experts on that one. Lax Forge, she can object to the officer testifying about other statement, like a coroner report, but will have the same officer testify to a trooper on cross. Well, that's typical, of course.
Excused, and we are proceeding. Mr. McBride.
Mr.
Yes, Your Honor.
McBride now.
We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of States Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection. I want to be heard. And I didn't know this was coming now. To be a link all of it.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Englehart from Turning Point USA.
All right.
And yeah, again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102, because if the court looks at the last paragraph of this, Mr. Englehart, who is the purported author, refers to himself in the third person. So it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? People can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument? Or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public
course.
our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance? And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3. Paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is. And I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence. And there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Engelhardt's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
It sounds like kind of a wild 1102. Sounds like TPUSA is trying to correct the record about some commentary, perhaps?
And as the court knows, but I want the record to be clear. When I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression.
He will.
And now I'm quoting the statute as
You
the
can't stop
personal
him.
attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K.
So he's making a point.
I'm sorry, the 1102 statement
This is a good point.
is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of
Drop
Mr.
that in
Kirk's
real quick.
political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's
He's
a
got a
second
point.
level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical
Matthew
question.
9.
If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, I can't see where else it fits into this case. I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says.
Harsh,
It doesn't
but true.
matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt, who I've never met.
It's true. Doesn't matter.
The book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are
Shout out
in
to
any way
Doug.
what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. When I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned
It is an appeal to sympathy.
that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, and we can engage in that, but it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage
How dare you?
is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so
I'm always
just to give
going
an
to stand up
overview
for
of
Mr.
what I'm
Novak.
intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you.
Yeah, this
Mr.
is
McBride.
definitely taking us to lunch. Explain to us, Mr. McBride, how this relates to your charging decision that is based on
the
politics.
evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Your Honor, can I lodge an objection to Mr. McBride reading which you're discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this
He
language
has it in front
that
of
is
him. He can read
relevant
it.
and probative. I don't know how I can make an argument something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. Not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible.
Okay.
I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to
He's right. It's
confuse the
super
issues in this
shady
case
to get your evidence out in
and
public.
create fair trial risks for Mr. Robinson.
All right.
While
Thank
you're
you, Mr.
arguing
Novak.
about
any final thoughts before
whether
I
it's
rule on this
admissible.
specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits.
Yes, you can.
If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just
Yes,
so
you can do
cumbersome
that.
to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, and noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain
thought it was
points
9.
in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role.
I love the
So,
restraint.
the objection has been sustained to Mr. McBride in regards to your response, the rebuttal to the argument by Mr. Novak. What is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, if the court rules on that, I will make my full argument.
All right. Well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty. I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument.
He's playing helpless.
So do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing.
No.
I do
He's
not want
telling
to close
you.
the hearing. I do not believe it's necessary to close the
Paraphrase.
hearing. That's not my motion.
That's all you
I
have
do,
to do.
however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence,
He's not the
in
one
my
being
argument,
reasonable here.
then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without
This is
quoting
just
it
digging in and being
verbatim in
stubborn.
open court.
Of course you can. Or you could paraphrase.
No,
This is
I don't
not-
think so.
Not rocket
All right.
science.
Your Honor, if you're going to make the closure ruling,
All right, I'll hear from
Media-
you. as
media
well.
wants
If you
to
would
say
like to
in
come
that.
forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure. Thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar or however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta.
Of course he does.
857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits. That was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss, because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment. It's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility. That's all.
All right. All right. I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. Magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial.
Very true.
Taking this into consideration, I look to the information, going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement, in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds. But at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service, the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully in making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Kind of a backpedal there. Kind of undermines the reasoning you gave before.
Thank you.
Kind of looks like he just gave
5.1
into his temper tantrum.
Is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3, that these events discussed political issues as well as religious issues. Most political issues in the portion I previously quoted talked about gender issues, in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. It talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity.
See,
For that
look how
reason,
you're
Your
doing
Honor,
this without reading it.
This exhibit is relevant. I don't see the prejudicial unfair prejudicial effect this would have on the fact finder, whether or not it has, some capability of prejudicing the potential jury pool. I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here. And but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the alleged allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that. And that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually, the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is, what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions, or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson
It doesn't have to be in
had,
this document. It's in the other evidence that you mentioned that he told us is Tyler's own words.
with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine, and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what
Fair.
Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence the state is proffering to prove a very narrow point. And it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think that the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself. And so I'm just going to stop
Well
unless the
past.
court has questions.
Love you, Mr. Novak, but you're well
I don't.
past
Thank you.
that point.
Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question
Nice
to
dodge.
be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. That's, I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the
No,
question.
I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement
That's a good point.
based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom. The state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right. Anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right. In making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated. And is this relevant? What is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression. And the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see.
You all look like shit. I need to give you the full hour.
Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
From the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right.
Well, that was quite a little detour. It's rather extended. I know my Mr. Slovak takes some heat from the chat here, but I have to say I do understand his point. They're separate aggravators, and the state only charged one of them. The state didn't charge the religion aggravator. I also understand the judge's point. These aren't real crystal clear categories. Because of course a person's ethical and moral beliefs are going to be informed by religion, and they are going to inform your positions on politics. So like maybe it's a really bad distinction, yet it is there. And it is what they chose. They didn't charge the religion targeting. But at the end of the day, I do struggle with this one a little bit. Because just the whole idea of like, oh, now it's just any kind of specter, the thing the queen is holding, not that. Any kind of specter of this case litigating religion is really not good. It's just really not good. And this is already a risk in a community with the highest percentage of certain religious beliefs. It runs the risk of introducing the sympathies into the case, the othering, the in-group, out-group stuff. He's one of us. He's not one of us. He's a good guy. He's a bad guy. He's, you know. It makes me very uncomfortable. That said, I haven't read the thing either. It doesn't strike me as the kind of thing that sounds crazy prejudicial. Yeah, it sounds like it's more about Turning Point USA and Charlie than about Tyler. So, like, is it gonna hurt to like lay out kind of what some of the basic religious foundations, the foundational beliefs of Charlie and Turning Point USA were? I don't really see that. Other than just this whole kind of positioning thing. These are the Christian people like you, prospective jurors. This guy is the anti-Christian, as Mr. Novak put it. That's the risk. But the thing is that exists in this case independent of this particular declaration. So, yeah. Interesting little sideline, interesting little philosophical question there about the intersection of politics and religion. I do kind of wonder what the legislature was thinking in making that distinction. The reality is they probably weren't. It's just one of those things, because legislatures are lawyers, that lawyers do. I do hereby give, bequeath, convey, devise, like, it's just use all the synonyms, you know, like use every word for the thing. I feel like that's what it is. It's just trying to be, you know, really comprehensive with your list, but not like really thinking about the validity of the categories or anything like that. Well, boy. That was fun. That's going to be part of a fun part of the recap, I think. Working through all that. The judge. I mean, it's fascinating to me to see the dynamics and just like the personal interactions. Here's what I saw. You guys might disagree with me. It's totally fine, but this is my channel, so I'm going to say what I saw. What I saw is Mr. McBride cross the line, do something he knows he's not supposed to do. He knows he's not supposed to read from the exhibit when it's not in evidence. He knows that. He knows that. Just like it's not supposed to be published before it's admitted. They know this. And Mr. Novak called him out on it and asked for him to be spanked. And that got Mr. McBride's back up. He didn't like that. He didn't like it being implied that he needed to be spanked. And they're probably already, the prosecution team, a little bit touchy because they just did get spanked over the contempt thing, the gag order. Now, it wasn't a particularly hard spanking in terms of like what the actual consequences are. Look around. Not really that big of a deal at the end of the day. But they don't like it as a matter of principle. Prosecutors see themselves as white hat people. They see themselves as white hat people. And so therefore, you know, the idea that they've done a black hat thing is deeply threatening and challenging and stuff. So I think he got his back up, and then he dug into, you know, I not only have the right to do this, which he's wrong, he doesn't, but also I have to do this. There's no possible way I can make my argument without reading the document. And that's just bullshit. Come on, that is just a tantrum. You're a lawyer. Of course you can paraphrase. Like, half of your job is paraphrasing things that people said so that you can color them the way that benefits you and then try to put that in their mouth. It's part of what a lawyer does. So what you're saying is the whole Kathy Newman thing. So yes, he can. And that was really, I found that like, to me, a full on toddler crossing his arms, stamping his foot. I can't. Yeah, you can. But he was mad because he got accused of crossing the line, which in fact he had done. Didn't want to be spanked. Judge, I think is seeing, you know, he's in this tantrum mode. And Judge, who has previously said, of course you can't read from the exhibit, it's not in evidence. That's standard, and that's the process that we're following here. Now backpedals. Because he sees he's faced with these kind of extreme choices, right? He can spank Mr. McBride publicly, which is going to make him mad, and you know, he's not going to like that. Or you can just cave and let him read this whole document and, like they said, defeat the purpose of having a discussion about whether it's even admissible. So he backpedals to try to find this middle ground of, well, you can't read the whole thing, but maybe you can read you can read pieces. That would be okay. It's not okay. It's not okay. You don't get to just partially, in a way, it's kind of worse to read part of an exhibit that's not admitted into evidence, because now you get to be selective, and so you get to, you know, be misleading to the extent it's not in context. But he's gonna back away because Mr. McBride has put his foot down. Okay, well, I'll let you quote some, so we don't have to have the closed hearing, because I do think the media lawyer makes very good arguments. The judge has paid attention to the media lawyer like throughout this entire case. So he finds the middle ground. He gives this concession. Yes, you can quote a little bit, even though like that's probably not right, could be problematic. And so then what does Mr. McBride do? He takes that and makes his argument without quoting from the document again, like we all knew he could in the first place. There's like a psychology going on with this interaction that I would love to study. how this went, and just from the conflict resolution standpoint, how that worked, because it did. Everybody got what they wanted, other than, you know, us who want to see the thing who haven't gotten to see it, but that's just a yet at this point. But everybody got what they wanted, right? Mr. Novak got what he wanted. Mr. McBride didn't read from the exhibit. Mr. McBride got what he wanted. He didn't get spanked. They got there. That was quite a thing to behold. Personally, I enjoyed that thoroughly. I understand everybody else's kind of annoyance and trepidation and so forth, but I really enjoyed that little interlude that we had. And I get the points. I get the points, and I don't think that this is a frivolous objection. I think that is very valid. The statute specifically distinguishes between these two things. But I also appreciate it's hard to do that in practice. In reality, there's always going to be overlap. Of course, especially for somebody who is a high-profile political speaker and influencer who has religious beliefs. Of course, there's going to be spillover. So, yeah. I don't mind. I don't mind having the late lunch as a result of that. Let's get through some of your guys' comments and questions and stuff, and then I will do my step away. Do need to check the trees because we are having a heat wave setting in today. I need to take a little bit extra time in case I have to spend a while watering out there. Oh yeah, this is what was up when we went back into section. She can object to the officer testifying about the other statement, like the coroner report, but we'll have the same officer testify to a trooper on cross-examination. Yeah, I mean it's classic. Of course it is. You know, of course it is. That's the fun of lawyering. If you're not real concerned about principle, then you don't have to be consistent. It's just going to be what benefits you in that particular argument. Mara W8658, really hard for defense attorney to explain away the fact that he turned himself in before any suspect was identified. Why would a random, not guilty individual do so? They're going to have to explain it if they are going to argue factual innocence or make a case for factual innocence. Even just a reasonable doubt case, you know, nothing affirmative that they're presenting, not, you know, alibi or anything like that. They can go through and point to, like, there's another bullet in a crowd and a lot of people hated Charlie and lots of people had motive and stuff like that. Okay, but you still have to explain the totality of the evidence. And why did you think you were guilty? Why did you think it would be a good idea to go to, why did you think the police would be interested in you? Going to be hard to explain and not impossible. I mean, very few things I think are impossible to come up with some explanation. It's just that it's, you know, it's got to be plausible. Preferably it's got to be strong, and a really strong explanation for this seems hard to imagine. The best thing I can think up that I can think of that they, you know, might go with, just a possibility, would be that once his parents contacted him with, like, you know, the gun, the father had asked to, you know, ask for him to send a picture of the gun, and he didn't respond to that. And then his mom wanted to know where he'd been, and he lied about where he'd been, you know, said he was homesick. And then, of course, the photograph being out, and they thought it looked like him. Those are the things I remember from the legal documents in the case. So he could think, like, well, it was, you know, even if it wasn't me, enough people were going to start to think it was me, that the police were going to be interested in me. And so I just went ahead and turned myself in to try to get ahead of it. It's an explanation. Is it plausible? It depends on a lot of other stuff, like how good is their evidence, all these other things. The corroboration, location data, DNA, on top of the video, top of the statements, all of it. I think it's going to be tough to sell, and that's why I think they're anticipating. It's good mitigation, but really, really incriminating as it goes to guilt. Your gal PJ, the insensitive phrasing that she is using was his exact wording during his testimony yesterday. I don't think she's doing it on purpose. His testimony yesterday was dead center. And she did use that a couple of times as well, the dead center, which is not good. But she had her own. She had her own creative one. Let me find what it was here. Words, Kathy. The dead on view. The Ty Phillips video showed a dead on view of Charlie Kirk and the security team. I can't say I've never used words that maybe on reflection could come across as a little bit tasteless. I'm sure we all have. And as you point out, the witness did too. But it wasn't just a quoting the witness back to him. It was also like some of her own. It's not the worst sin in the world, but I'm just, I am going to notice it. Like, ooh, that's just a little cringe. Mara W8658, does it hurt the mitigation case at all to be seen laughing in court during a murder trial? That's going to be up to the jury. They get to take into account his demeanor in court and stuff like that. So it's kind of an individual thing. I know this is going to sit very badly with a lot of people. It doesn't so much to me. I talked about this when I was on the Charlie Kirk show last night. From the defense lawyer's perspective, their main priority is their client's comfort and well-being. whether he's guilty, whether he's innocent. Their goal is to get the best outcome for him and for him to be comfortable with it. And I think that's elevated in a case like this, where you have a guy who has no apparent criminal history. He's not the jailbird, that already knows the ins and outs of the system and the process and stuff like that. So he's finding himself in court, likely for the first time, probably doesn't know much about it, doesn't seem to, like, at least if we take his face value, his text that as long as he could get his rifle back, he wouldn't have left any evidence. Like, oh, you naive, you naive child. No,
All right, guys, I'm going to keep the stream on, but I'm going to be show prepping. I've been show prepping this entire time behind the scenes. I'm going to be doing that in the background. I'm going to have this muted here, and you'll be hearing all the clips and stuff that I'll be arranging in the background. So I'm going to be doing this actively while this continues to keep going, and yeah, I'm trying to juggle all this all at once, guys. So I appreciate all the love, fam, and thank you guys for the gold pills. I appreciate that as well. We got Khaleesi for the can, Kim Iowa, thank you for the cookie, Jack Attack with the cookie, Neo with the shades, happy Taco Tuesday. Thank you, Neo. Lobster Mobster throwing down a fleet. Appreciate that, my friend. And Dougie, thank you for the cookie, my friend. I really appreciate that. So I'm gonna continue working, guys, behind the scenes here while we wait for them to get back to lunch. The only way I can continue doing it. And we'll keep rocking and rolling. So this is going to stay muted. You're going to hear a bunch of other clips in the background while I work my show. So we'll keep doing it. I'm going to mute up now.
In Muslim culture, we call cruelty obedience. I hate
On our national mall, we're celebrating freedom's triumph over tyranny, liberty's conquest over oppression, and the enduring victory of the American spirit from the July 4th, 1776, than ever before. Truths. They declared that all men are created equal. Here are
but people wouldn't believe how
violent it is. And I've seen the battlefields. They send me pictures. I actually want to say, don't send them to me. Pete, this man right here sends me pictures. Pete Hegseth. And I said, Pete, you know what?
Troop drawdowns in Europe likely?
The drones, but
Plattner leads by 9 points. Out indicates Fox survey out indicates the Senate race in Maine is shaping up to be a very close contest. Our new poll finds Republican incumbent Senator Susan Collins has a small 3.
Twice. Qualifications.
rape, murder, arson, and rape.
You said rape twice.
I like rape.
video of this guy with a
How did you find Graham Plattner?
Well, so, I mean, we went through thousands and thousands of prospects. Then, Leanne pulled up this video of this guy with an oyster farm.
My name is Graham Plattner, and I live in Sullivan, Maine, the owner of Frenchman Bay Oyster Company.
And then she pulled up his FEC history and saw, the money he'd given to Bernie Sanders and, some other people. And that was enough information to know that we had the best prospect.
You're talking to your sources. What are they telling you right now?
Yeah, Aaron, we actually have some significant news that was just released by the Democratic Senatorial Campaign Committee. This is a joint statement between the chairwoman of that committee, Kirsten Gillibrand, and the Democratic leader, Chuck Schumer. Here's what they wrote, quote, "The allegations reported today are incredibly disturbing. Violence, abuse, and sexual assault are absolutely unacceptable. Graham Plattner needs to immediately withdraw as the Democratic nominee for Senate and allow Maine Democrats the opportunity to choose a new candidate."
According to yeah, I know Sneeko, and I could just tell you, living on the internet every single day and doing everything that you do for clicks and attention will lead to brain rot and just evidence Sneeko. There's a reason that all the guys that he was once friends with, once that he admired, once that he allegedly, according to Andrew Tate, tried to hit on him, have no longer want to associate with him and have nothing to do with him. As they say, he's crashing out. Let's just say Andrew Tate did a whole expose basically saying there's one guy that I will not deal with ever again, and that's Sneeko. Shocking that someone named Sneaky Sneeko, turned out to be a snake. Nicholas. The second person is Nick Fuentes. Nick Fuentes says he's a brown clown after being good friends with him. Those two guys basically hate each other at this point. It just basically shows that what America stands for is not compatible with what the Islamic ISIS type mentality stands for. And then obviously Destiny has basically destroyed him multiple times. But this is
And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. again, he seems to be having issues walking. That's the vehicle. The driver of the vehicle is.
And where is this parking structure located on campus?
It's just. It's a maroon colored T-shirt with gray or olive colored shorts. He does, yes.
Okay.
Purchase some food.
From there, where does he go?
From
Sure, it's on your screen.
it's approximately a T-shirt and shorts.
Like what area?
A gait or a limp in this video. He comes up around Campus Drive, as you can see on the video here. There is a cut through there, north hearing on the.
And again,
they move behind the.
Mr. Robinson now.
I do, yes. He's just arriving at the corner of the building. Almost the top center of the root in his hand at this.
The quadrants, where is he currently?
In the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been.
Yeah, what was today like?
Greg, thanks so much for having me on. And today was an emotional day. There's no way around that. It was grueling, and I could see the emotional toll that it took on, I mean, really all of us, but of course, Charlie's family. But I will say this, that Erica, Kirk, and Charlie's parents are some of the strongest people that I've ever met. And watching them walk in there and face that absolute evil head on is one of the bravest things and most courageous things I've ever seen anyone do. And sitting just feet away from where Tyler Robinson sat, and I will tell you this, Greg, not once did he turn back and acknowledge us. Not once did he turn back and acknowledge the family, express remorse or anything like that. I didn't see a second of him doing that. In the courtroom, seated in the front row.
The most disliked trailer of Christopher.
Kamala Harris would be a much better president than Donald Trump. Welcome in.
Hi.
Hi. So do you mind if I give you my reasons why I think that Harris would be a better president?
If you want.
Yeah, so there's two main categorical reasons why I say Harris would be better than Trump. The first category is character. The second category is policy. Let's start off with character. First of all, Trump is Trump is a felon. Trump is a fraudster. Trump is an election denier. He's a dictator on day one, wannabe fascist. Okay. Kamala Harris is none of those. Kamala Harris wants to protect and preserve a democracy. She wants to fight for the freedoms of all Americans, especially the 170 million American women and girls. And then we could reference policy next. If you want to respond to character, go for it. If you want me to hop straight into policy, I could do that too.
Well, starting with character, I technically do not think she's a good person. Speaking of which, if we're bringing up stuff from the past, we can say she slept with Willie Brown, broke up a family just to get her job. And while she was there, she used a firm that was putting people in jail that had false positives on drug tests. And she knew they had false positives. She admitted to that. And she was still putting mainly Black and brown people in jail, considering I'm both. That is very much a big issue for me. And also that a woman shouldn't represent, they should just sleep to the top for their job. They should actually work hard for it. I generally don't think that she's a good representative. There's plenty of other women out there.
Yeah, I have a question. How many votes did she get in a run for AG? Do you know? Now, how many votes did she get in a run?
We're talking about character, though.
Of course.
That's
We'll talk
character
about
and morals. And if we're
that's-
mentioning character and morals here, she's clearly not a good person.
I'm responding to your
just
claim.
like you had mentioned all that stuff about Trump, which could be true.
I'm
She's an
referencing your claim
adulterer
that she.
and a family.
I'm referencing
wrecker.
your claim that she slept to the top. How many votes did she get when she was running for AG and DA in the state of California?
But that has nothing to do with the fact
It does. She got
someone-
4.5 million votes in total. 80 million for her run for AG or DA. I don't remember which one. And 4.4 million for the other one. I have a question. You're saying that she slept her way to the top. How many of those 4.5 million people that voted for her did she have to sleep with?
Well, obviously we're in California and this is pretty corrupt, but to say that she needed the votes of most people that matter, which is the person she slept with, could actually overturn and hide these votes just like they did with the election. But
Listen, the idea that women have to sleep with men to get into positions
and that's
of power
exactly what she
is a
did.
misogynistic
Exactly what
lie.
she's exonerating.
One moment.
She's saying that
Do you mind if I finish talking real quick?
we have to open our legs to get jobs. That's exactly how she used it.
Do you mind if I just finish talking real quick? Also, I would like to finish out this conversation. There's a lot of red flags up though. So saying that women have to sleep with men to get into positions of power is a misogynistic lie. What
I
you are
didn't say
doing,
that. She just
one
did
moment,
that.
one moment.
That's what she represents.
What you are
That's all I'm
doing,
saying, guys.
what you are doing is you're taking Kamala Harris, you are taking her character, you are taking her proposed policy, you are taking her intelligence, and you're taking her wisdom, and you're throwing it out of the window. Because when you say that the
You did the
only
same thing
reason
with
she's
Trump.
in her position of power today is because she slept with a man that had been legally divorced for 3 years is a lie.
didn't.
She got
She slept with
4.5
while
million
she was
votes to get into
married.
AG and DA and slept with 0 of them. The question I have for you,
Oh, you don't
is
know
how
that,
do you feel
though.
about
Do you
Donald
know
Trump?
that? No.
Okay,
Absolutely
so
not.
you think that she slept with 4.5 million people to get in her
she
position
could
of
have,
power?
but the one
Wait,
person that
are
she
you
did
serious?
was the most important person.
Did you just say that she
did-
had to sleep with 4.5 million
No,
people?
I didn't say that. I said that she slept with one of the most relevant people to get her
What
job,
was his
to
name?
get in. Willie Brown.
And how
I
did
just said
sleeping
that.
with Willie Brown get her the 4.5 million votes in her run for AG
Because
and DA?
he was in the same position she needed to get.
But we have civil and electoral processes. We are a constitutional
honor
republic with
those?
democratic processes. Yes, I do. And you're saying that she somehow circumvented these civil and electoral processes?
I don't hate women, guys. Just letting you know.
Donald Trump is a racist.
Islam.
Just another day. Just another day. Just another day. Oh, someone's been
What the fuck? Laura Loomer?
Akbar! ここはアメリカのイスラム公箱だ。イスラムは全ての家庭に浸透する。マムダニのニューヨークへようこそ。アッラーよ、どうか私の罪をおやぐしください。私の心を清め、私の
limping up the stairwell. This occurred shortly before Charlie Kirk's assassination. You can see Tyler Robinson trying to conceal his face right here. And if you notice, he briefly looks back at one of them to see if they're looking back up at him. They believe that Tyler Robinson was concealing the rifle inside of his pants.
Again, he seems to be having issues walking.
And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track? So, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay.
Ha! Woo! Oh yeah!
It seems the only thing the party establishments can agree on is a love of Jeffrey Epstein and a hatred of me. I'm Graham Plattner, and I approve this message because together we will take back our government from the...
I mean, that's beast mode to be like, everyone who hates me is a pedophile. He's running the most, they're calling this the most Hasanabi campaign of all time. Okay.
tree about the most is my hornbeam, and it's my best tree. It's a beautiful tree. Very, very not native to this type of environment. I mean, the environment where I live is hostile to life generally. We are hot, dry, arid, windy. Just not the kind of thing that plants in particular, yeah, really tend to like it to thrive in, unless you are a Russian thistle or a Artemisia, sagebrush kind of thing. But the hornbeam in particular seems to have a really hard time with it. It's used to a humid, cool environment, and it can't move the water through itself efficiently enough, like be able to cool itself when we get all hot like this. So I got to pay a special attention to it, and I'm glad I did. It did need it today. So court still has a few minutes before they come back, find where I was in my notes. So I'm ready to come back after the lunch that Judge Kraft was like, y'all look terrible. Go eat a hamburger. Come back with your good mood. Well, I mean, what? He didn't, of course, say that, but I kind of felt that in the subtext of what he was saying there. Oh, let's continue with what you guys have had to say. Michelle 8190. There is a big difference between how the judges, prosecutors, and lawyers' demeanor in this trial versus young thugs. Everyone seems so calm in Utah. Do you have any insight onto why? Yeah, I mean, I've talked about this a little bit. I really do think it's cultural. And I think part of that also relates to the culture being more high trust. This is a more high trust, small community, very LDS influenced. People look out for other people. Everybody is on the same side, kind of mindset. And young thug Fulton County is like as polar opposite from that as you can get. I mean, they are battle lines. They are sworn enemies. They hate each other. They deliberately obstruct each other. They don't seem to be real big on, I don't know, the law. I didn't watch hardly any of Young Thug, but even I couldn't miss the Brian Steele getting thrown in jail. Like, are you kidding me? Over your ex parte conversation with the prosecutor's judge? Yeah, I couldn't miss that one. And it's, I mean, it's sad. It's unfortunate that from my perspective, there are far more Fulton counties in the justice system than there are Utah counties here. Because it's just, it doesn't have to be that way. It's not a good thing that it's that way. It's a very toxic thing to be that way. Maybe that is like just the inevitable consequence of having an adversarial system. You know, if the other person is your adversary, then you're going to try to beat them. And then that turns into the, focus being on winning. And then when the focus is on winning, it's not about justice. And it's not that, Utah's like uber concerned about, justice to the, exclusion of Fulton County. But I do see a lot more of just accommodation and reaching across the aisle and taking cooperative approaches to things. They seem to be very good at doing this meet and confer and working out a lot of stuff. Great example, these witnesses the defense wants to call. Does the defense have the right to call them? Almost certainly not, under the standard that we've already seen get applied. Because for them to have the right to compel a witness to come in and testify at the preliminary hearing, they need to have some kind of proffer, some kind of showing that it's going to undermine probable cause in general. And that means we're not just talking about, I could believe your evidence or I could not. It kind of means we need to take your evidence off the table altogether. So they didn't have to agree to that, but they did. A lot of places wouldn't. So many places wouldn't. You think Nick McClelland is going to be like, oh, sure, defense, go ahead and do something you don't have an unimpeachable right to do. A right that can't be avoided, that I can't convince the judge you don't actually It's just a very different dynamic. And so, yeah, I mean, it's one of the things for me that there's every case has its own dynamics and everything. And boy, the whole public commentary side on this one is just a whole life of its own. But the courtroom dynamic, the vibe itself, oh, it's so refreshing. It's like a comforting warm bath to watch this trial in this court with these participants. I mean, really, I feel like this temper tantrum that we got from McBride today is like the pinnacle of conflict in this court. It's the most conflict thing that we've seen. And the defense has been like accusing the prosecutor. Conflict of interest, contempt of the gag order. Like, there are lots of materials here to gin up hostility and antagonism and sniping and arguing back and forth and just deciding not to be cooperative anymore. I'm not going to make their job easy. I'm not going to help them out. I don't owe them anything. I'm not seeing that. We're seeing so much grace. I really sincerely appreciate it. Darlene Dunlap, 6693. Does it matter? Ultimately, is he the person responsible for shooting CK? Everything else is noise, in my opinion. Love the coverage, Andrea. Thank you. I mean, it literally just matters for that limited issue of the targeting enhancement, and for that purpose, is it the most important thing? No, it's not. Like, I buy that the relevance is pretty minimal. But it's not zero. It's just low. And that's why Mr. Novak, he's bringing up Rule 403. He keeps talking about 403. 403 is a balancing test. That's the test that exists in the rules of evidence. And I mean, pretty much every jurisdiction I've ever seen, certainly the federal rules and everything, that the presumption is if evidence is relevant, it's admissible. But the exception to that is 403. Even relevant evidence can be excluded if its value is outweighed by its potential for prejudice. If it's more harmful than helpful, even if it's relevant, you can keep it out. That's really what they were trying to show here. I don't think they really got there, because I'm kind of in the boat of I'm not really seeing the harm here. Like, I'll buy that it's minimally relevant. It's not relevant, but it is minimally relevant. I'm just not seeing what the harm is about. All right, we get to see what Charlie Kirk and TPUSA's views are. How is that harmful? I can feel like the gist of it. They don't like the lines being drawn. This side is Christian, that side is not Christian. But that also seems to be a little bit hypothetical, a little bit skeptical. And I think it's also a little cynical. You know, I mean, I'm not a Christian, guys. Wasn't raised in the church. Nothing against it whatsoever. A lot of respect for a lot of the beliefs and practices and so forth. It's just not my personal community. But you know, that said, my understanding of Christianity, and like certainly the Christians that I've worked with, that I have the most respect for, embrace the sinners. It's literally like not about, you know, I'm the good guy, you're the bad guy, you're damned to hell. It's about embracing the sinner and offering a helping hand. Oh, I had I will always praise. I need to look up the name now so I don't get it wrong, but one of the Presbyterian churches in Walla Walla. They ran the warming shelters in the winter. They ran a prison reentry project. They walked the walk when it came to, you know, ministering the suffering, the sinning, offering the help. And I have so much respect for that. So I feel like it's a cynical view of Christianity anyway, to think that, like, okay, even if somebody is kind of characterized as here as disagreeing, that means they're going to hate him, they're going to want to convict him. I think they would see him as misguided and they would pray for him. That's what a good Christian would do, just based on my experience with Christians. But feel free to correct me, because like I said, It's not my particular culture, but it's not not one that I take issue with. Definitely when it's like I said, walking the walk, very impressive. Base player 2011 IFY. I disagree. The defense opened the door. They could have just said this document doesn't show my client's state of mind, but he didn't. That's fair. That's fair. That is a risk for Mr. Novak, right? He fills the space with his voice. Problem is, the more you talk, or you might talk too much, and then you say something that opens the door to something you weren't intending to. I feel like Mr. Novak would benefit his trial presentation from becoming comfortable with the silence. You really don't have to fill every second. Part of the issue is he thinks out loud. He's a very, very smart man. It's very clear. His thoughts go everywhere, but they haven't gotten to their destination and mapped the route by the time, you know, when he's opening his mouth. So it ends up being that, like, he's talking while at the same time he's like trying to Google the location and then like check the directions and then make sure he's not gonna, you know, back into somebody and then so I think that when he is operating off the cuff like this, he's a very organized thinker. It's crystal clear in his writing. I've looked at a lot of his briefs and things like that. He's a very, very organized thinker. And so when you're off the cuff, you know, if it hasn't crystallized like that, exactly what your logical structure is, I think he struggles with that. So, yeah, I think it might help him to simplify, become comfortable with the silence. Because, yeah, I can't disagree with this. I mean, I think at least to a minimal extent, yeah, he did. He's the one who brought it up. Now, does that, again, require Mr. McBride to read from it? I don't think so. I don't think so. Mr. Novak characterized it. You can characterize it your own way, too. That's not hard to do. But, you know, to the extent this was like, I don't know, this wasn't as bad as like you headbutted me so I bit your ear, but it's the same kind of vibe. Like, one of these was more of an escalation than the other. My view. Looks like court is
Mr.
back
McBride,
now.
turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time. And we're going to call an FBI DNA analyst out of order. It's a defense witness. That's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I think I got her name wrong. Hang on.
Forward and be sworn in.
Let me find the witness list real quick. Falmuina.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September
FBI.
10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means evidence response team.
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low-C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay.
I love her. I already love her.
What was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31.
We're still waiting to find out what Exhibit 35 was that was mentioned yesterday and isn't on the list. The list ends at 34. See if we get there today.
That's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from the FBI?
Sorry, yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objection.
All right, so I'll note the standing objection and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Bird? The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay,
Mr.
if you'll go to...
Or Ms. Nestor left for the
Kimberly,
day?
if you'll scroll down to still on page 1 where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines there that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser or rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it is.
On September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from title item 7 until the word contributors?
We can't hear you, Mr. Burt.
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burt.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So if we've got the report in evidence, we don't need this witness's
He doesn't want us to hear it.
the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Already skipped several pages.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burt, cross-examination.
I'd like to reserve the right to cross-examine after the testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the party?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
Oh.
There we go. You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled B-A-K-K-E-R.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority 1 level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think
Did she talk
the
to
pages
Hall?
are numbered. So I'll ask you to go to page 22 of your case file notes.
Get case information from Hall. That'll be hilarious.
Okay.
Won't surprise me at all.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
That's her telling them.
You
not them
told
telling
them
her.
that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
And Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that this will be just to the witness, not to the public.
Okay.
Calling up tab 7. You see that? See that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
And I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in a report and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
Yeah, it's definitely relevant.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the meeting?
Yes,
okay.
Correct.
Any?
Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct. No, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct. It was
irony.
not.
Okay. And then the next
we're
one.
going to talk about this.
Not that one. One more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm sorry. Can you clarify your question?
Yeah. when it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mm-hmm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct.
screen.
This is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
What is probabilistic genotyping? Tell us.
And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4 fourth down, one more. No, next one.
We're going to get into all this. I love this. I love that Mr. Bird is doing this. He's been doing this for
does
decades.
the policy state an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in the report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down.
He's good.
Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
A formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation based on my experience that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my data?
Wouldn't be very degraded if they're getting a 30 quintillion likelihood ratio.
So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of H, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars.
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now,
Oh, are you going to do next gen?
and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between two individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
All right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex determining locations. One is Y-indel and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
She said 7.
I did a profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci.
That was the one.
Yes, it is.
That was a sex determinant.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, DYS 391 is actually that male location. So he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson's a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
Right? And then by the
He's
same
showing us his
organization,
library.
National Resource Council, the evaluation of forensic DNA evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and
love
your
this show and
continuing
tell.
education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that. Forensic DNA Typing Methodology.
Yes, I'm familiar with that one as well.
And Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
I would say so.
And would you also agree that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that.
It's a statistical challenge.
14, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident based on our validation, our testing, and my training that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14-15, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question and I'm moving on.
All right, Mr. McBride.
I'll hold him to that.
All right. Well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your
STRmix.
Statistical results?
The software is called STRmix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to STRmix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAS called into question mixtures of 3 or more individuals with that minor or that low level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the STRmix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates the likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to STRmix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence of the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant. And I think it goes to the issue of reliability. And it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the light most favorable to the state. And I think we're beyond that point now, getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that, analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same. It could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce?
I believe so, yes.
Federal agency?
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just to make sure. That it's a long report, right?
Yes, it is.
And you've read it?
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complex?
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where again the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 in paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again, is not precluding
You're asking him to weigh
if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure. And I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, you know, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. So based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes. And could you display for the witness page 365 of tab number 4?
How many of you are lost? Are you riveted by this? How many of you are riveted
by the way,
this?
it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct, based on how.
All right, guys, I'm going to be shutting the stream down so I can set up for the show, which is in 30 minutes. Thank you all for hanging out, and thank you guys for the Go Pills. Super appreciate all of you, as we always do. We're going to be starting the regular show here in about, 30 minutes. So we'll be doing that. So we'll see you guys here in a little bit. Much love, fam. I'm going to send you over to Drunk Pinata, actually, real quick, as we shut the stream down. Thank you very much, fam. We'll be covering all this and so much more. See you in a little bit. Goodbye, my friends.